Second case we have before us is Ammar al-Batha and Shahira al-Sham versus State of Florida Agency for Healthcare Administration. Is the appellant ready to proceed?
Yes, Your Honor.
You may.
May it please the court, my name is Floyd Fagley. I'm here on behalf of the appellant. I'd like to reserve 5 minutes for rebuttal. This case is very straightforward. It involves a petition filed at the Division of Administrative Hearings to contest the amounts payable in satisfaction of a Medicaid lien asserted against a wrongful death settlement. The petition was filed by the personal representative of the Medicaid recipient's estate and the decedent's surviving spouse. The matter proceeded forward and was set for final hearing. The Agency for Healthcare Administration, AHCA, filed a motion for summary final order, which was opposed. Their position was that under the plain language of 409.910, paragraph 17B, only a recipient may contest the amount payable to the agency by filing a petition at the Division of Administrative Hearings, and that though it lacked jurisdiction because the petition was filed by the Medicaid recipient's personal representative of his estate and his surviving spouse. The motion
so they're arguing for a very narrow ruling of what recipient is. That just means that in this case the person who received the medical care, not someone standing in their shoes. That's their argument, basically, right?
That's their argument, and that's the argument that the administrative law judge adopted. The administrative law judge dismissed the petition, granted the motion for summary final order, and dismissed the petition with prejudice, citing to another administrative law judge's decision in a case called Nunez versus AHCA, or Delgado versus AHCA. The administrative law judge determined that dead Medicaid recipients cannot challenge the amount payable to the agency under the 17B administrative proceeding, and that personal representatives cannot file that petition, so they dismissed it.
Why don't you think AHCA's argument makes sense as a purely textual matter? 17A talks in terms of a recipient or his legal representative or any person representing agent, blah, blah, blah. But 17B talks exclusively about a recipient may contest the amounts. So here they're arguing for a reading of recipient that's limited to recipient versus all those things that are talked about in 17A.
Well, the administrative law judge said that the 17B was clear and unambiguous, that only a recipient may contest the amount payable. And in this case, it was the recipient who was filing the petition through his personal representative. 17B does not provide or state that the recipient must be alive or make any reference to the death of the recipient.
But that's where 17A is interesting, right? Because 17A says a recipient or his or her legal representative or any person representing or acting as an agent for, so there's more than just that word recipient in this same part of the statute.
Well, there's an easy explanation for that. 17A is a provision that requires all persons who receive third-party benefits to either pay the Medicaid lien within 60 days or place the money into trust. It's a provision that requires protection of the agency's rights, their money, pending some type of determination. So yes, it includes everybody under the sun, the recipient, their legal representative, their attorney, anyone who touches third-party benefits must protect them. And then 17B creates the cause of action that we're here today that says the recipient may file a petition to contest the amount payable. And that's exactly what
And I
occurred.
guess my simple point would be that they could have said a recipient or his personal representative or legal representative just like they did in A, but they didn't.
Or even easier, the legislature could have said a living recipient may contest the amount payable, and we wouldn't be here today. But in this case, the statute says a recipient may contest, and under Florida law, an individual's rights do not die with them but survive and may be commenced or prosecuted by the person prescribed by law. And the Florida Probate Code and the Florida Rules of Civil Procedure outline that a personal representative is the proper party to bring the claims of the deceased individual.
What about his widow?
Well, in this case, we don't need to necessarily address that because the personal representative has filed the petition in addition to the widow. The action would survive just with the personal
I
representative.
understand, but your argument doesn't quite cover her status, right? She's not the legal representative, not the personal representative. That gets into the really other issue, which is the interplay between the wrongful death statute and the Medicaid and the anti-lien law, which you can address at your leisure, but
Sure.
just ask you to comment briefly on the widow status
In
in
regard,
this proceeding.
in regard to the surviving spouse ability, standing alone would likely not be the legal representative of the recipient, but the personal representative of the recipient's estate is the proper party.
Right. Assume we agree with you. What about the interplay with the statutory lien provisions, the rights of the Medicaid, of the agency to recover the Medicaid medical expenses and the wrongful death statute? Is there any limitation on the agency's ability to recover 100% of the medical expenses from a wrongful death settlement?
Well, the 17B applies equally to personal injury settlements and wrongful death settlements. 17B makes reference to it being the exclusive method for challenging the amount of third-party benefits payable to the agency. Third-party benefits is a defined term in 409.901, paragraph 28, which includes personal injury settlements and wrongful death settlements explicitly.
So some of our-
17B
Yeah, Mr. Fagley. So some of our brother and sister courts have held that the Medicaid lien has to be, in the case where the recipient is dead, the Medicaid lien has to be fully satisfied before any is apportioned for, any of the various categories, like Gohagan out of the fourth, Hernandez out of the third, Strafford. Are you distinguishing from them, or are you arguing that they're wrong and we should strike out in a different direction?
I think they're inapplicable.
Okay.
100% inapplicable, because all of those decisions, Hernandez, Gohagan, Stratford, England, and Ross, all deal with a trial court's ability to determine the agency's payment. 17B involves the administrative law judge's ability to determine the amount payable and provides the exact relief we're seeking. So there's no need to turn to those cases to figure out what an administrative law judge's responsibility is under the 17B, because those cases all deal with a trial court's authority. 17B was created to restrict these actions only to the Division of Administrative Hearings. So all we need to do is look at the plain language of 17B to get where we need to go. Now, Gogahan and Hernandez, well, let me back up. Stratford, England, and Ross were all decided before the U.S. Supreme Court's 2006 decision in Auburn. Hernandez and Gohagan were decided in 2016. And what they said was the anti-lien statute only protects the property of a living Medicaid recipient. And that may be true, because the anti-lien statute says that no lien may be imposed against the property of an individual prior to death on account of medical assistance provided. Hernandez and Gohagan only looked at the anti-lien statute, period. That's it. Hernandez didn't cite the other important provisions of federal Medicaid law which are applicable, and mainly the equally important anti-recovery provision of federal law, which is one paragraph below the anti-lien statute, which states no recovery may be made, period. It also did not address the assignment authorized under federal law, which is only the Medicaid recipient's right to recover. Only the Medicaid recipient gives his right to recover medical expenses to the agency. That's done through an assignment. The Medicaid recipient's family does not give any right to the state of Florida to recover, and the Medicaid recipient does not give his right to recover other elements of damage other than medical expenses. And so Hernandez, Gohigan, they don't look at the anti-recovery provision of federal law. They don't look at the core assignment granted to the agency. They just looked at the anti-lien statute and said, it makes reference to the death of the Medicaid recipient, so it can't apply. And accordingly, federal law does not preempt the agency's recovery. I've outlined in my brief that that's wrong. And interestingly enough, the ALJ below, ACCA in their answer brief, none of them cite the anti-recovery provision, which this court cited in Geraldo, noting that the anti-lien and the anti-recovery statute prohibit recovery, with the only narrow exception being the Medicaid recipient's limited assignment. So federal law confirms Medicaid may only recover from the portion of the settlement representing medical expenses. I'd like to reserve the remainder of my time.
May it please the court, I'm Elizabeth Teagan. I'm with the Attorney General's Office representing the Agency for Healthcare Administration. And I'd like to just start right in trying to answer some of the questions that were raised. Specifically, what happened in this proceeding, or what the basis of his ruling was, it was a plain language interpretation of the statute. And the statute at that time, which no longer, does not read the same now, it was amended in 2017, restricted the availability of this administrative proceeding to a recipient. And in fact, as Judge Osterhaus pointed out, that subsection B says a recipient, subsection A says a recipient, his or her legal representative, his attorneys. A imposed a very broad obligation on, as counsel conceded, on a number of people who are potentially in receipt of settlement proceeds to ensure that Medicaid's lien is set aside. B, with the very next subsection, the legislature intentionally restricted that proceeding, which allows for a challenge to the Medicaid lien to overcome the amount that is presumptively due to the agency. Restricted that very specifically to recipient. That's it. It's a very plain language interpretation that the ALJ did here. And it is correct. The statute was amended in 2017 to broaden the availability of that proceeding from recipient to a recipient and his or her legal representative. There's been no case law yet on what his or her legal representative is, so whether the widow constitutes a legal representative for purposes of that proceeding is not clear. And not really at issue in this case, at least it wasn't briefed by us. So the court is asking, what about Gohigan and those other cases that came out of the Florida appellate courts that treat a wrongful death settlement separately from a personal injury settlement? And there's a very good reason for that, because yes, in fact, Medicaid can file a claim against a decedent's estate for the entirety of its outstanding lien. And it does so. And actually, Gohigan and a couple of other cases arose out of probate proceedings. So there isn't a case other than this court's decision in Delgado that really addresses whether who is a recipient for purposes of that administrative proceeding under the 2016 law when the proceeds are received in a wrongful death settlement. So this ALJ took on that issue and said, just a plain interpretation of the statutes is clear. The legislature restricted it to the recipient, him or herself, and if the recipient has died, there is no right to proceed under 17B. And this is consistent with the legislative intent that's articulated, especially by the Florida legislature. And I don't need to quote a lot. I'm sure that the court is very familiar with the Medicaid lien law. The number of issues have appeared in front of this court. But the express legislative intent in Chapter 409, the Florida law, is that because Florida has agreed to participate in this federal-state joint welfare program, which is what Medicaid is, it is incumbent on Florida to seek reimbursement the entirety of its Medicaid lien to the greatest extent possible when there's a liable third party. And the legislative intent says Medicaid is to be repaid in full from and to the extent of any third-party benefits, regardless of whether a recipient is made whole or other creditors paid. And it is intended that if the resources of a liable third party become available at any time, the public treasury should not bear the burden of medical assistance. So, you know, consistent with that, the legislature decided in 2013, when they created this administrative proceeding after the Supreme Court, United States Supreme Court's decisions in Alborn and Voss, where they were directed, all the states were directed to make available some proceeding to a recipient to challenge the amount of the Medicaid lien in the event the recipient had received
If a Medicaid recipient, for example, has minor children, I'm not sure what the situation is here, but in terms of the children, but a Medicaid recipient has minor children. The Medicaid recipient is killed in a wrongful death situation. A settlement is reached so that there's some recovery, both to the taxpayers and to the estate. The argument is that although we now know that with a living recipient, the state cannot attach 1 penny more than the proportion dedicated to medical expenses. In a wrongful death, let's say it's a $2 million settlement, and half of that was pain and suffering for the deceased and loss of consortium, whatever it might be, into the estate, that the Medicaid program can take all $2 million of that for payment of medical expenses.
Well, I mean, the state,
even though much of that recovery that went to the estate was specifically not for medical expenses.
Well, keep in mind that the legislature, in creating this and implementing the federal Medicaid law, has not actually, has sort of capped, in essence, the recovery by Medicaid, because there's a statutory formula that is used.
Well, let's say my hypothetical, the statutory formula or the amount that was decided by the ALJ is their medical expenses that were rendered to the deceased were $1 million, but the deceased lawyers obtained a $2 million settlement that went into the estate, and Medicaid comes in and says, in my hypothetical, the estate obtains $1 million as a settlement, but specifically, all parties acknowledge, as here, that only $500,000 of that was the proportionate dedicated to medical expenses. Medicaid could still obtain the entire $1 million and deprive the heirs of the remainder of that settlement.
So the statute, this formula, is probably not going to allow Medicaid. It's going to cap Medicaid's recovery at an amount that is net of attorney's fees, 25%, and then what the remainder net of those attorney's fees is split between the Medicaid recipient and ACA. So I think if your question is ACA going to recover in that scenario where there's a wrongful death settlement, the full amount of its lien, when the lien exceeds or equals the total amount of the recovery? I don't think so, because the statute caps that recovery. I think.
Well, maybe I'm misunderstanding something, but here the medical expenses were $143,000. The proportionate part of the confidential settlement dedicated to the medical expenses were $68,000 thereabouts. Medicaid said we will not accept the $68,000 or thereabouts. We demand $143,000, the total amount. Your argument is, in essence, correct me if I'm wrong, that, well, this is a wrongful death action, that went into an estate, we get the entire $143,000 from the estate.
I think the argument, that's certainly the logical conclusion of the argument in this case, is that there's no ability for anyone to challenge the presumptive amount that the legislature has allocated for repayment to ACA. That's correct.
So if this case had gone to trial and the jury rendered a verdict that said, okay, this amount was pain and suffering, this amount was loss of support for kids, this amount was medical, we wouldn't be here. Since the jury determined how much was medical, that would be all that Medicaid could go after, correct?
Those aren't the facts.
Well,
think-
I know.
I think actually the statute.
We ask questions about things other than the specific facts of these
Sure.
cases.
I just had to give you that predicate.
Yeah.
I think actually the statute allows ACA to even look behind a jury award. However, having said that, I don't know what ACA would do in that scenario where you have specific findings, presumably, on a jury award form, where there is an allocation, a very specific allocation, this much is payable for this much is payable for that. If there's an allocation for past medical expenses, federal case law does limit ACA to the recovery in a personal injury case it can only collect from the proceeds or the judgment of the award that are associated with past medical expenses. So, I'm assuming that there would be a limit on what ACA could collect there, and it would probably be pretty compelling evidence if you have a jury award form saying that there was only this much awarded for past medical expenses.
So let's say we say the estate is a recipient.
Sorry?
Let's say that we hold that the estate is a recipient, okay? How do these other cases come in? Gohagen, Hernandez, how do they come into play?
Well, I'm going to look at the brief that I filed in a previous case because Hernandez and Gohagen really didn't deal with what recipient means for purposes of the administrative procedure. They both arose from probate proceedings. So although they are consistent with the argument we are making.
So he says they're inapplicable and you
Well, no, I'm not saying they're
largely
inapplicable.
agree.
No, I'm saying that they are consistent with the idea that wrongful death proceeds are treated, for lots of good reasons, very differently than proceeds for purposes of Medicaid and reimbursement of Medicaid. That, in other words, the federal law does not preempt Florida law when it comes to wrongful death
Attaching those
proceeds. Yeah, right.
Okay.
Wrongful death. Just because the whole idea, I think, of the federal scheme is that the anti-lien provisions, and counsel references the anti-recovery provision in federal law, but really all that does is say ACA can't recover any more than it's entitled to recover. It's not, but the anti-lien law, which is kind of the meat on the bones here, the anti-lien law, according to Gohagen and Hernandez, the anti-lien law, the federal law, does not preempt state law when it comes to wrongful death proceeds, again, in a probate proceeding. That's all. It was just a preemption issue in those cases. Geraldo, the court may be familiar with Geraldo. This court issued an opinion and it went up to the Supreme Court, and the Supreme Court reversed. The issue there was very limited. It was whether ACA could actually recover from future medical expenses, from settlement proceeds that were allocated to future medical expenses. The answer is no. That's what Geraldo said. We are not dealing with that in this case. Future medical expenses are not at issue. But Geraldo was actually a wrongful death action. But oddly enough, the issue of whether Geraldo, who was the decedent's personal representative, could go forward was never at all. The timing in that case was very unique. Mr. Villa was alive at the time his personal injury action was brought, but I think he received his proceeds as they were personal injury. It was a personal injury settlement, but then he died before the 17B proceeding, or in the middle of it. His estate was allowed to go forward under 17B, but the facts were very unique in that case. No one briefed the ALJ or this court or the Supreme Court as a practical matter on whether that was I think that it was determined that it was not a factor. Everyone just conceded that the case could go forward, but I don't think that's a holding that recipient includes the estate of a deceased Medicaid recipient for purposes of going forward under.
So if we hold, contrary to your argument, that a personal representative is a recipient, the estate, does the case get remanded then, obviously, for the ALJ to determine the proportionate amount of the medical expenses that are recoverable by your agency? Or does this get into an area of the law that we, at least this court, hasn't addressed, which is the entire wrongful death settlement up for, I don't want to say up for grabs, up for recovery by the agency in the estate proceeding?
I wish I could answer your estate questions, whether the entire amount is available to the estate as a claimant in probate. I was remiss not to brief that.
And I appreciate that. If we, because you won below and it was dismissed, so we essentially didn't get to the merits.
I'm going
right?
to assume.
I'm
that-
sorry?
I'm going to assume that the agency can go forward as a claimant in probate and recover, because as I understand the
That's
probate.
what was going to be my question. Is that something we should address? Should we determine the estate as a recipient? Should we allow the parties additional briefing on that point, in the sense of, if we reverse and hold that an estate as a recipient, is that dicta to address what amount of a wrongful death settlement is recoverable?
Let me say this, my understanding of probate, which is limited, is that the PR is constrained somewhat about distributing proceeds from lawsuit settlements. For this very reason, the probate code and the case law associated with that puts constraints on the personal representative in distributing those proceeds. So it's maybe entirely the case that ACCA can seek the full amount of its claim, and I don't know that that would be inconsistent with the probate code. Does this court have to address that here? I do not think so. I think
So basically, if it's remanded, then the only question on the table is, the ALJ will then address the merits to determine what percentage of the $143,000 is recoverable?
if the court
Am I wrong on that?
If the court were to remand it, that is certainly one of the issues that.
What
would have
other
to-
issues would be on the table?
Well, I don't know. I wasn't counsel in the lower tribunal, so there was no pretrial stipulation. It was summary order. It proceeded to summary order. So I don't know whether there a fact, he made some findings in his, the ALJ made some findings with respect to the amount of the proceeds, not necessarily the allocation. So I don't know, but if the court were to remand it, I think it's possible that it would go back for an evidentiary hearing on how the award was allocated.
Right, I mean, that's the central question in
Right.
these proceedings, right?
That's.
Your total amount that you seek is $143,000 thereabouts.
That's right.
Their argument is that proportionate recovery ought to be reduced to somewhere in the neighborhood of $68,000 because they took 44% of $2,500,000. The ALJ will look at that and say, it's 143, it's 68, or something in between, right? That's the only question that will be litigated if we remand.
Quite possibly.
And if this happened now under the new statute, that's what would happen, correct? Since the definitions have been
Well, it
changed.
certainly happens in all cases involving a settlement of a personal injury case. That's exactly what happens.
But we're in new territory here, at least for this court, right? In
Sorry?
terms of, we're in new territory here in terms of a wrongful death settlement.
Well, I think it's sort of limited because the statute was amended in 2017, and probably a limited pool of people to which the old statute would apply at this point. I don't know whether there are others or not, but yes, you are in new territory, but I think the plain language of the statute, it is what it is. It was modified.
But that's a later proceeding anyway, right? The ALJ is just going to look at it and decide on a number, and then it's up to your agency and the estate to litigate what's recoverable from the probate proceeding?
Presumably, yeah.
Right.
Thank you.
Thank you. Would you like a few seconds to conclude? I'm sorry. We took a lot of your time on questions.
I do appreciate that. The agency is simply asking the court to affirm what the correct analysis of what the meaning of that statute is by the administrative law judge. Thank you.
Thank you, counsel. So we'll give the attorney for the appellant an additional 2 minutes and 20 seconds approximately, should you so need them.
I'll talk really fast.
No, you don't have to. I'm giving you the additional time.
I want to answer a few questions real quick. There was a question about whether this matter had proceeded to a jury, and a jury had awarded $63,000 in past medical expenses and awarded the remaining amount to the surviving spouse to compensate her for her pain and suffering, mental anguish, and the other damages she's allowed to recover under the wrongful death statute. What would happen in that proceeding? As the statute's written, Medicaid's entitled to recover from its full lien from all portions of the settlement, except for this provision in 17B, which provides that the recipient may contest the amount payable by filing a petition with the Division of Administrative Hearings. This is the procedure. In that circumstance, a petition would be filed with the jury verdict, and the administrative law judge would be asked to limit the agency to the portion of the settlement allocable, which should be allocable to past medical expenses. That's what the remainder of 17B says. If the determination is that only living Medicaid recipients, if we're going to insert the adjective living in front of the word recipient in 17B, if that's done, under that fact pattern, when you have a jury verdict, the agency is entitled to recover from all portions of the jury award. The $63,000 allocated by the jury to the estate for its past medical expenses, and the amount allocated to the survivors, which in this case would be the surviving spouse, but oftentimes it's minor children, and that's a wrong result, because the amount awarded to the children, surviving spouse, is to compensate them for damages distinct from medical expenses, for their pain and suffering.
You go ahead, Judge.
Oh, I was just going to ask, why was 17B changed in 2017 to include exactly what you're asking us to read into the statute now? Do we know the impetus?
There is no legislative history on it. I'll tell you this. There was a few words added at the very beginning that says, if federal law permits restriction of the agency's lien. It says something to that effect, the 2017 version. Because Congress, a number of years back, passed a law taking away this ability to limit the lien according to federal law. And the state of Florida was anticipating that that would take effect. That provision of federal law was repealed in February of this year, so we're back to how federal law has always read. So they were anticipating a change in federal law that did not take effect. And that's why it was changed. That's the only reason, and there's no legislative history really explaining much more than that.
But on the wrongful death and the whole issue of recovering, which was my question about the minor heirs, surviving minors, if we rule on your favor on the question of the personal representative is a recipient for purposes of determining a proportionate share, at this point we don't get to the amount recoverable, right? In other words, am I correct in that?
You're correct.
Okay.
Absolutely.
So if you go back and you prevail here and the administrative law judge says, I find that the proportionate amount of the $143,000 that is recoverable is $65,000. And then the agency then files in the probate proceeding and says, we want the entire $143,000 that we expended for medical care because we're entitled to that because this is wrongful death and not a living Medicaid survivor. Is that the likely scenario, a possible scenario?
That is an impossible scenario because 17B addresses that specific point.
Okay.
What I'm asking you to do today is determine that the plain language of 17B does not require that the Medicaid recipient be alive to file the petition.
No, I understand that. I'm saying if we rule in your favor on that point, do we need to worry at this point about the interplay between the wrongful death statute and the anti-lien recovery, if you will?
Absolutely not. The remainder of the statute says that the administrative law judge will make in order to successfully challenge the amount payable, proof must be provided as to the amount of third-party benefits which should be allocated to past medical expenses. That's the responsibility of the administrative law judge to make that determination later on. And the statute also says that this procedure in 17B is the exclusive method for determining the amounts payable to the agency. I think it
So
would be
you don't foresee
impossible.
the agency having an argument subsequent to that proceeding in the probate proceeding when they seek recovery from the estate of exceeding the amount determined by the ALJ?
Not under 17B, Your Honor. It would be quite hypocritical for them to say you can only challenge our lien at 17B through the Division of Administrative Hearings and then go back to the trial court and say, trial court, give me more money. Does it work? I think that's an impossibility. So what we're asking today is just that this order be reversed and the matter be remanded back to the administrative law judge to determine the amount payable under 17B. Thank you.
Thank you both. Thank you for your arguments. The court is in recess.
All rise.